Hi, my name is Akiva Goldman, and I'm an attorney with Goldman and Associates, and a prospect called in and asked what requirements are there in order to be a guardian. Are there requirements to establish a guardianship? Well, number one, you're going to have to prove to the court that there is a need for a guardianship. In most cases, when we have guardianship, your most common type of guardianship that we've seen is a guardianship where there's an elderly parent who has become infirm, or who has become unable because of dementia and other reasons to take care of their needs. In that situation, you might have a younger relative petition the court for guardianship. The court would probably want to see some medical records to support the need to give the power over one person from himself to another person. It's a big step. The relinquishment of power and giving that person to become under the authority of another person, from a legal standpoint, that requires the court to make certain determinations. So number one, the court has to establish that the person even needs it. Now, need is a loaded term. Need can go from a profound need to a need where the court thinks, you know what, the person's doing okay, but he or she's a little bit forgetful, might not take medication, might need or benefit from a little bit of extra help, so yeah, we're going to appoint a guardian. It could be that simple. Once the court determines that a need is met here, that the person qualifies, that there is a need for a guardian, then the court has to say, well, who's the guardian going to be? Now, normally, if one person files a petition for guardianship and there is no objection, and there's no other family members coming forward, the court will honor the request and appoint that person guardian. But it's not always the case that that's so simple. Oftentimes we have competing petitions for guardianship. Sometimes allegations arise really challenging the person to be a legitimate, trustworthy, qualified guardian. If that happens, the court has options to conduct a hearing, to pick between different types of guardians, to establish a co-guardianship where more than one person has to weigh in on it. And sometimes the court can say, you know what, you're saying he's no good, you're saying he's no good. That, with both of you, the court is appointing a guardian of its own choosing. Which could be a lawyer or a service or some person that nobody knows, but with whom the court has experience. Oftentimes that happens as well. If you have any questions about this process, please reach out. We'll be glad to help you out. If you found this helpful, please like, comment, and share.